Yes, welcome on the channel. I want to greet you in a glorious manner, and Brighton Mtajeshi is my name. Today the topic of emphasis is land ownership from Land Law 1. So now what you have to put in mind is when we are explaining land, you have to start with Article 237 that explains and says that all land is vested in the citizens of the country, in Ugandans. So the land, in simple terms, the land belongs to the citizens of Uganda. But we see the exception that says that non-citizens will obtain land through leasehold, as we are going to see. So in this essence, Article 26 clause 1, it also provides for a right to own property, which means a person can have a right to own property. That's it. You can own property, you can build there a house, you can do businesses. As long as you have your property, the right is given to you by the Constitution, Article 28 clause 1, 26 clause 1. So when you look at Section 2 of Land Act provides for land tenures, which means the land shall be categorized in tenure systems. There are four. One is Milo land, customary, and customary, leasehold, and freehold. But before that, what you have to put in mind is that before the 1900 land tenure, before 1900 Buganda Agreement, land was basically obtained, all land was obtained in what we call customary. So after the coming of the Europeans, they had to distribute land. That's why we saw they gave the land to the king of Uganda, so-called Milo, and the other remaining land was freehold. So other parts of Uganda minus Buganda Kingdom, that was what we call freehold. Now when we start with freehold tenure system, freehold, this means that you will have land in perpetuity, meaning it will be your land forever. And in this essence, it means you may have a title over it. No one should come and take your land. It's yours. You have it in perpetuity. And again, you can use that land, you can lease, you can mortgage, you can rent. So in this essence, you have to understand that this land, this system, freehold, came from the crown, because remember, the other land of Uganda was Mile. So that was given to the Kabaka, or the kingdom, and again the other remaining land was seen to be freehold, because any person there outside there had land in perpetuity. So that's it. When you look at the history, of freehold as it started, we see that it had roots in medieval England after Norman conquest of 1066. In year 1066, we saw that land was also belonged to the king, which means the land of England was vested in the powers of the king. So which means that the same king or the kingdom had the ownership over the whole land of England. But again, now when you look at types of freehold, whereby we have fee simple, life estate, and fee tail. This means that in such essence, when you do something let's say you have served in military, after some times they could say, now come, we give you land. Or you have done something great for the country, they give you land. So it was the power of the king to grant land to the citizens of England. So which means the king had that power to give land to those people. We had what we call the people who could oversee the future, the people who could say that in like two years this will happen. So when those people could predict right, they could be given some land, they could be given a reward as land. When you look at fee simple means that when they gave you land, that land was obtained absolutely or in perpetuity. When they gave you that land, you take it forever. Now, when you look at life estate, for life estate, they could give you the land, but when you die, then the ownership ceases. It goes back to the king. That is life estate. For fee tail, this was given to you. When you die, that land could be given to your bloodline, to your, let's say your son, your daughter. As I have said, this kind of estates, or this kind of estates was given according to what you have done. They could grant you that land according to what you have done. So that is the theory or the history of freehold. When we look the freehold in Uganda, I have said this is having land. Like if I go, I buy the land, it is mine. We make a land title, we go, we process a land title, then I have the land that is freehold. Unless having that land on Milo. So that's it. So when you look in 1955, where the governor of England, I told people, basically in the parts of Chigezi and Ankole, to go and register their land, which means that those people, after registering, they obtained what we call freehold, freehold type. So in this essence, let's look at customary. Now, for customary, this is the form of tenure system, and for this, it is enshrined, or it is provided, and it is provided under Section 3 of Land Act. And this was land that was this was land that could, or it's land that follows the norms, the custom, the culture of the society. So which means having that land, you must be in line, you must follow the norms, the rules, the cultures of the of that area. So in this essence, that is what we call customary land. But note, you have to understand that even customary land can be registered. When you look at Section 6 of Land Act, provide for registration of customary land ownership. So, and the certificate is issued by the land board, which means the customary land, you can go and may process what we call a land, a title, a certificate over the same. In the case of Ranyerale versus Uganda Land Commission, they provided and said that customary rights exist even if without registration. So, as we have said, even if it is not registered, it can also exist customary rights. which means customary land tenure is enforceable by the law, whether registered or not. Read the case of Kampala District Land Board versus Venetia Babgeyala. Venetia Babgeyala. So read that case, you will get to understand. Now let's cross and see the other type, that is Milo. Milo land, basically section 3 cross 4 of Land Act. Milo land came into existence under the 1900 Uganda Agreement, where we saw that the land was distributed into two ways. One, that the crown land and the Milo. So the Milo belonged to the king, to the kingdom of Uganda. That's Milo land. Then for the crown was the rest of the lands, such as the green pasture, the lakes, the rivers, and whatever other things like that sort. Those are and other land, big land. They divided land into two. So we saw that the kingdom were given 255 square miles, and in this essence, which means the other land was the crown land, as I have said. So when we look into deep of Milo land, we saw that in Milo there is what we call a chibanja, the chibanja holder. A chibanja holder is that person who owns land and have that obligation, have the rights to use the land. He can rent, he can sell, he can go ahead and do any other thing. But again, this land, it belongs to the kingdom. But again, the other person comes in and have a chibanja. But the other thing you have to put in mind is that that person will always pay what we call obusulu, or the ground rent. You understand? So in this way, those people is bibanja pay rent on that land. So when you look the case of Lukwago versus Bakwa and others, it says that it speaks about having rights on chibanja holder. So the chibanja holder have exclusive possession, that no person will come and intervene. He will be free to use the land any way he wants. So he will be the landlord of the same. So we have another person who can stay on Milo land. That is, when you look at section 29 of Land Act, talks about the bona fide occupant and lawful. When you look at lawful occupant and bona fide occupant, this is where the person have been on land 12 years back without any claim from another side for 12 years before the coming of the 1995 Constitution. So that person will qualify to be a bona fide. And a lawful occupant is that person who will have rights. The person who bought the land, the person who've been on land for some time, so is there in lawful means, whether he was just given that land by the government, let's say, he is there in a lawful way. So that is a lawful occupant. Now let's look at another type, that is leasehold. Leasehold is explained under Article 3/5 of Land Act. So what we have to understand, a leasehold is that you will be on land for time limit. As we have seen, Article 237, which says that all citizens, the land will be vested in the powers of the citizens. All the citizens will have the power to control the land of Uganda. All the land belongs to the citizens. But again, they are saying, as the exception, 237 explains that for non-citizens, non-citizens will obtain land only through acquiring leasehold and for 99 and below years. Which means if I am an outsider, I come from England, I come from Kenya, I will not buy the land, I will just lease. But for the case of Ugandans, they can also lease, which means they lease. There is what we call a leasee and a leaser. A lease and a leaser. The person who leases and the person who is given that land to use for some time. So the purpose is that person may be there to develop the land, to use it to do other forms, other works on the same. So that is leasehold. So you have to understand that. So thank you for watching. Thank you for listening. I salute you all. Stay blessed.